If you want contempt enforcement in a custody case, this opinion is a reminder. The order has to be crystal clear. And enrolling a kid in a sport is not the same thing as scheduling events on the other parent's time. Hi, I'm Ron Funk. I'm a California certified family law specialist and a certified appellate specialist. And I've appeared before the Orange County Court of Appeal, the 4th District Division 3, which is the court that issued this opinion many times over the past couple decades. I'm also on the ACFLS amicus committee. We reviewed this case as an unpublished opinion and voted to request publication, and the court granted that request. The opinion isn't long, and it's not trying to be a treatise, but the holding is useful. This came up as a writ proceeding challenging a contempt judgment. The trial court found the mother in contempt on 5 counts and imposed a $10,000 sanction total, $2,000 per count, based on alleged violations of custody-related orders. And remember, contempt is quasi-criminal. That matters because appellate courts construe the underlying order strictly, and ambiguity usually cuts against contempt. The contempt findings were built primarily on 2 lines from a prior order. First, the parties shall share joint legal custody. Second, a restraint that said, paraphrasing, neither party shall schedule school, extracurricular, religious, medical, or other events during the other parent's custodial time without approval. So the question becomes, when you read those words like a statute, because in contempt, that's how you have to read them, do they clearly prohibit what the mother did here? One of the most practical holdings is this. Enrolling or authorizing a child to participate in an activity where the coaches, leagues, or schools set the schedule is not the same as scheduling events yourself on the other parent's time. That distinction matters because if the order only forbids scheduling, contempt can't be expanded to cover things it doesn't actually say. The court treated scheduling as a word with real boundaries. So if you're trying to enforce a schedule-related restraint through contempt, you need order language that actually covers the conduct you're complaining about. Enrollment, commitment, signups, approvals, whatever the real-world mechanism is. The other key piece, and one reason we push for publication, is the court's discussion of Family Code Section 3083 in the joint legal custody context. Section 3083 basically recognizes that courts can and should specify the circumstances when both parents' consent is required. And when the order doesn't specify that, the statute contemplates that either parent acting alone may exercise legal control. So here, the trial court treated joint legal custody as if it automatically required mutual consent for things like extracurricular participation and orthodontic care. The Court of Appeal said, in effect, not on this record and not with this order language. If you want mutual consent requirements that are enforceable, you need the order to spell it out. There's also a detail in the opinion that really stuck with me. There was a team mountain bike event, and when the visiting parent objected, the custodial parent pulled the child from the event. Legally, the court treated that as undercutting contempt, because it wasn't proof of a willful refusal to comply. But from a human standpoint, it highlights something that shows up in real cases all the time. In high conflict custody litigation, parents often end up fighting about the child's schedule like it's a scoreboard. Who won the weekend? Who got their time? Who got overruled? But the child is the one who pays the cost. There's no real discussion here of what the child wanted. We can reasonably assume a kid who's joining teams and doing a mountain bike event wanted to be there. And when adults turn those activities into leverage, whether it's to control time, punish the other parent, or prove a point, the child's life gets smaller. So yes, this case is about contempt standards and order specificity, but it's also a quiet reminder that the goal isn't just enforceable language. The goal is reducing the adult conflict so the child can keep being a kid. Here are 3 trial practice takeaways I'd keep. 1, if you want contempt enforcement, draft orders with precision. Contempt lives and dies on the exact words. 2. If you intend joint legal custody to require mutual consent for defined categories, sports, therapy, orthodontia, use Section 3083 as your roadmap and make the order explicit. 3. Use verbs that match reality. Scheduling is not the same as enrolling, authorizing, or committing. If you want to prevent unilateral commitments that affect the other parent's time, draft it that way. If you're handling a family law trial case and you want appellate proofing on the front end, order language, preservation, record strategy, I do consulting with trial counsel on that. As always, this is educational, not legal advice. If you want the slip opinion link and a short written practice pointer summary, it's in the description. Thanks for watching. New published opinions, short practical takeaways whenever they drop.